Welcome. This is a special meeting of the Council of the Corporation of the Municipality of Central Elgin. It is Thursday, May the 1st at 4 o'clock. I welcome those who are here in the council chamber, as well as those that are joining us online. Council, are there any disclosures of pecuniary interest, please? Seeing none. We have a delegation, Paula Lombardi, who's the partner at Siskinds, our Central Elgin legal counsel, who will be presenting on strong mayor legislation. Ms. Lombardi, if you'd come to the microphone, please, and just push the button as you are all too familiar with. Thank you for being here.
Good. Thank you, Your Worship. Good afternoon, everyone. So it's my understanding that you have a presentation in front of you in addition to a chart. So we will tell you when to turn to the chart, but I'm going to briefly take you through the presentation. And then it's my understanding that we'll do questions at the end if that's okay. Some of it will be methodical and dry, and I'll go over fairly quickly. If you want me to slow down, let me know, because some of it is really process and less substance. It's just a procedure. So what we're going to do today is we are going to talk about the Minister of Municipal Affairs and Housing's comments on the amendments. The purpose really is in terms of why this was delegated and why the act was passed so quickly. Just a brief history of strong mayors, and then an overview of really the intent of the strong mayor powers, which is the legislative powers, administrative powers, budget powers, and exercising the powers. And all of these comment from MMAH Minister Rob Flack, heads of council being the mayor, are key partners in our efforts to build homes and infrastructure across the province by extending strong mayor powers to these additional municipalities, the 169. We are providing mayors every tool at our disposal to empower them to get homes and infrastructure built faster. Mayors know their municipalities best, and we support them in taking bold actions for their communities. That was what prompted this piece of legislation to be enacted. So a brief history of strong mayor powers, very briefly. So this is not new, it's newish. So pre-2020, I don't like this language. This is the language that the ministry is using. You have the weak, what they call the weak mayor system, which is the system as we knew it pre-2022 before any strong mayor powers. Following November 2022, we have the Strong Mayors Building Homes Act 2022. It enhanced the strong mayor powers for the mayors of Toronto and Ottawa only. And then in December 22, it's expanded that in terms of that framework of the strong mayors. Then in 2023 to 2025, those enhanced powers were extended to 46 municipalities. And then May 1st, 2025, another 169 received strong mayor powers. So this is new to a lot of municipalities, so there are a lot of questions. So if we just go to the slide after this, that's the May 1st, 2025 amendments and everything flows from Ontario Regulation 530/2022. Essentially, what the purpose of this was to streamline local governance, cut red tape, and accelerate the development of housing and infrastructure in line with those provincial priorities. It was to support a shared provincial municipal priorities, such as encouraging the approval of new housing, constructing and maintaining infrastructure to support housing, and any road and transit projects. And the proposal to expand the strong mayor powers, it was to include certain single tier and lower tier municipalities with a specific council composition of 6 members or more. And that was the whole intent and purpose, was to streamline local governance, encourage the approval of new housing, and constructing and maintaining infrastructure, the broad infrastructure, roads and transit as well. So in terms of what are strong mayor powers, essentially what I just said: streamline local governments, cut red tape, encourage the approval of new housing, encourage construction, maintenance of infrastructure, and accelerate the development of housing. This is consistent when you think of the strong mayor powers as an overall provincial priority with the housing first agenda of this government. And we can go to the next one. So what are strong mayor powers? So strong mayor powers are as set out in part 6.1 of the Municipal Act 2001. So when I say act, I am referring to the Municipal Act. Legislative powers, number one. Legislative powers cannot be delegated and cannot be subject to a delegation. And I'll talk to you about in more detail what those legislative powers are. But it requires a council to consider a matter at a council meeting, to vote on a bylaw at a council meeting, and the power to veto those bylaws as adopted by council. And then your second is your administrative and political structure powers. Those powers can be subject to a delegation. If also, if there is a delegation, the delegation can be revoked, just to be clear. So those administrative and political structure powers are to your organizational structure with respect to your senior staff, your chief administrative officer, your heads of your local committees. All of that are your administrative structures. You can determine the structure of the organization and the establishment of chairs and vice chairs on your committees. The third one is budget duties. Budget duties cannot be delegated. So the only thing you can delegate is administrative and political structure powers. Budget duties is to the annual budget, the preparation and review. There is a power now to veto council amendments of the annual budget. That is what we call a supermajority. In your case, that would be a vote of 5 members that you would require in terms of that vote, which is the power to veto council. And there is an ability now for in-year amendments, which means there can be amendments throughout the year. So to get to the legislative powers, and so this, if anything, that slide as a reference point in terms of what can and cannot be delegated is well worth keeping out. But the best way to think about it is organizational structure, admin powers, your day-to-day operations of the corporate municipality, the corporate body, can be delegated. But you must retain your legislative and your budget duty powers. You cannot delegate those. So your legislative powers, which cannot be delegated, those there are in the act, you will see the language prescribed priorities. And now the mayor or head of council, which is the terms that are interchangeable, has the power to advance or protect certain prescribed provincial priorities. Those are the houses first, the 1.5 new residential units by December 31st, 2031. And then again, those utilities, constructing, maintaining infrastructure to support housing, transit, roads, utilities, other services. So those are generally your prescribed priorities, which are very broad in terms of their scope. The meetings with respect to the prescribed priorities, regardless of the procedural bylaw that you have in effect, which, as you know, you're required to have under the Municipal Act. Regardless of those rules, if the mayor is of the opinion that considering a particular matter could advance a prescribed provincial priority, the mayor could require council at the mayor's discretion to consider a matter at a meeting. And that's now defined in the Municipal Act. So that is a discretionary, it's not a shall, it could be brought up. So in terms of the bylaw powers, again, notwithstanding your procedural bylaw, if that bylaw, if it is proposed, if the mayor proposes it in terms of advancing a prescribed priority, that proposed bylaw could be put forward and require council to consider and vote on the bylaw at a meeting. And the mayor, the underlying ones are just the process. You have to provide a copy of that bylaw, a copy of provide the clerk and each member with the proposed bylaw and the reasons for bringing it forward. And it's the sole discretion of the mayor whether a particular item or a particular matter advances or interferes with those prescribed provincial initiatives and priorities. And that is done in writing. So the bylaw powers And I keep doing this because this is somewhat of a change, because again, notwithstanding your procedural bylaw rules, a proposed bylaw from the mayor is passed if more than 1/3 of the members of council vote in favor of the bylaw. So in your case, that is more than 3. Thank you. We were working out the math. The super majority is a little trickier in with the 7, but you are 3. And if that 1/3 votes in favor, it passes. Change, mayor can vote as a member of council. So it's no longer the mayor is a tiebreaker. The mayor, which is traditionally how we've operated in this realm, the mayor can now vote as a member of council. So the bylaw powers the relevant legislation. So this applies to, this new power applies to those bylaws enacted under the Municipal Act and the Planning Act are the 2 big ones, and some other small acts such as the Development Charges Act, and then a wide range of acts. What it does not apply to is your procedural bylaw, filling vacancies, annual budget upper tier, and annual budget lower tier. And that's because those powers can't be delegated. In terms of the veto powers, which we'll get into, which gets a little, I will go fairly quickly through these once we get into the procedural timeline, because we can do a chart afterward, because there is a process in terms of the number of days to respond and whether it's in writing or not. But again, notwithstanding your procedural bylaw, if the mayor's opinion is that all or part of the bylaw could potentially interfere or promote a prescribed provincial priority, then the mayor can provide written notification to council of their intent to consider a veto. So you get written notification that the mayor is taking this bylaw and saying, okay, it either is going to interfere or it is going to promote one of those prescribed priorities, and I'm thinking about vetoing it. So that's just a consideration realm. And that has to be done 2 days after council voted to enact the bylaw. So you have a vote, mayor then has 48 hours by which to determine whether or not they're going to give notice of a potential veto to the bylaw. Doesn't mean the bylaw is vetoed yet. It means it's a notification of that bylaw. And that process is set out in detail in a memorandum. Those veto powers, the day of the veto. So again, if there is a potential risk on the day of a veto, then there's a written documentation, and that's referred to as the intent to consider. This is where this gets a little procedural. So in terms of, I believe, the most pragmatic, because there's 2 days of an intent to, I would say, there to form them into the same document. Here is my intention to veto this bylaw, and here is my reasons of why I'm considering this. But it has to be written reasons. I would argue, for anyone's interest sake, that's because of the overlay of the Statutory Powers and Procedures Act, which means that you have to give written reasons as to your rationale for that. But I am a law nerd and I find that interesting. So just know that it has to be in writing. But I think to avoid an overly cumbersome practice, my recommendation would be that is done in one document. So then on your intent to consider vetoing, it's that bylaw. As soon as you get that written, the mayor is thinking about vetoing the bylaw. That bylaw is not in effect. It doesn't exist. At this point in time, it's hung in a mid-ground because it does not come into effect. It's unlike other bylaws that you have dealt with, many other bylaws, particularly in the planning regime. But as soon as you get that writing, as I'm intending to consider doing the veto, the bylaw is deemed not to have been passed by council. So if notice of intent to consider a veto has not been given, then the bylaw comes into effect following that 2-day period. If the notice of intent to consider vetoing has been given, then there's 14, then you go through the written approval, you review everything, and then we have another prescribed power we're going to deal with on the next slide, which is the override. So if a mayor vetoes a bylaw, The clerk has to, on the next business day, after receiving the written veto document, that intent to consider, provide each member of council a copy of it and make it available to the public. Then within 21 days after that, we have a super majority vote again, and that the clerk provides the intent to consider, and council may vote to override that. You need again, a super majority. And again, the mayor may vote. So now the mayor is stepping into the shoes of a councillor and can exercise a vote. In terms of the mayor cannot vote a bylaw after either giving written approval of the bylaw or the expiry of the 14-day period. So if you haven't done your notice of intent to veto it, and you haven't brought forward your reasons as to why you're vetoing it, well, now you cannot vote. You cannot veto the bylaw anymore. It comes into effect. So that the first 2 and 14 days are key in terms of ensuring whether or not a bylaw is going to come into effect or not, or whether it's going to be vetoed or not. I know this is becoming clear as mud, but it will get, this is the first time and it's a lot of information. There's prescribed periods, but we can develop lots of charts for you to help you facilitate this in a more practical process. So in terms of the administrative and political powers, which may be delegated, we're going to very quickly go over this. The powers of the CAO, those sit in section 229 of the Municipal Act, can be delegated back. So right now the mayor has the authority in terms of that office to hire, fire, those sorts of things. This just sets out what your CAO does. And the best way to think of your chief administrative officer, you guys are well familiar with, it's tantamount to a CAO of a business, right? Your chief executive officer of a business does all of your day-to-day operations, right? That CEO reports to the board. In this case, your CAO reports to council. Council is the bigger picture, the strategic ideology of the municipality, and the mayor has their certain authorities as set out under the Municipal Act, which includes economic development, the betterment of the community, all of those big picture things. Your CAO is your day-to-day operating authority. So the organizational structure, so the powers of the municipality regarding determining the organizing structure of the municipality are now assigned to the mayor. And that includes all of your hiring, dismissal, exercise of any of those prescribed employment powers. But again, those can be delegated back to their original form, which previously existed, which you have a clear, I don't want to say a separation because it's not, but you have a clear administrative organization who is running the body, the corporate body of Central Elgin, and then you have council, which is your board that is overseeing the strategic priorities. These powers, in terms of your organization, the powers that are granted do not apply to the clerk, the deputy clerk, the treasurer, deputy treasurer. The reason for that is, as you know, those are statutory positions set out under the Municipal Act, and the municipality cannot operate without a clerk or a treasurer. And it also applies to your CBOs, your police chief, your ombudsman, your auditor general, all of those. And there is a catch-all at the end of this that says any other prescribed persons, but none are prescribed to date. It also has, it also applies to, so this is your general authority under local boards and committees. You appoint chairs and vice chairs. In the committees, you create committees in terms of some of those duties that you want in terms of the municipality. The powers of the municipality are assigned to the mayor to either establish or dissolve those committees, appoint chairs and vice chairs of committee, and assign functions of the committees. I'm going to stop there very briefly, only because in terms of, and you can go, yeah, you can, in terms of this delegation, it again just reviews what you can delegate, what you can't delegate. So mayor can only delegate powers 1 and 4 to council, which is the powers and the duty of the CAO and committees. And the mayor may only delegate powers 2 to the CAO and council, which is the organizational structure. we'll go to the next slide and then I'll put in my comments after. I was just gonna think, because we'll get to the budget duties, which if you thought that first couple in terms of process was complicated, wait till you get into the budget. So there are now new budget powers. And the best way to think about it is the mayor holds the power with respect to the budgets, and there is a veto power in addition to an ability to bring amendments forward throughout the year. So all of those powers and duties relating to proposing and adopting the budget now are vested with the mayor. And the mayor, what happens now is the mayor is charged with proposing a budget for the municipality and then provides it to council for consideration. In terms of that structure, that is fundamentally the same of what exists now. You have a council, you have your senior administrative staff who all work in terms of preparing the budget. The only difference is now is it's going to be given to the mayor is going to review it and then present it to council. So the mayor prepares that proposed budget. After receiving the budget, council may pass a resolution making an amendment to the proposed budget, if there's any amendments when you have those discussions. But now the mayor can veto an any amendments to that. Again, the check and balance in this, because there are checks and balances to think of in this new legislation. Council can override that veto with a supermajority again. And again, the mayor votes as throughout this piece of legislation, the mayor now votes as a member of council. So those budget powers, they're assigned to the mayor. Council review and amends, right? There's a specified timeline now to pass resolutions, which is an amendment to the budget. There's a veto power. The mayor can veto any amendments. And then the super majority in terms of whether that veto is going to move forward or not. And then following which you have budget adoption. There is a specific timeline for the budget now. So it is now on or before Feb 1 of each year. It dictates now the budget preparation. And if the budget is not proposed by the mayor to council by February 1st, the council then prepares and adopts the budget. Within 30 days after receiving the proposed budget, there can be an amendment to the budget. And in terms of those amendments, those occur within 30 days, that 30-day period after you're reviewing the budget. If council does not pass any amendments within those 30 days, it can be a shorter period if you want. I would say 30 days is probably short enough when you're dealing with your budget. It's deemed, the budget then is deemed to be adopted by the municipality. And then the budget is adopted in accordance with the regulations that are set out, which is similar to the standard, what exists now. The budget veto. Within 10 days after those 30 days where you can pass amendments, the mayor may veto any amendment that's passed and can shorten that 10-day period for a veto resolution in your own discretion. The next one, if the mayor vetoes an amendment passed by council, that amendment is deemed not to have been passed. It does not become part of the budget. And if the mayor does not veto an amendment, it then becomes part of the budget. There is a budget override position in terms of after, and these timelines are better in a chart when you think about them once you get into it, but after 15 days of the expiry of the time period to veto an amendment, so after those 30 days, and then now you have a period of 15 days, council can override the mayor's veto again by a supermajority, and again, the mayor may vote. If the override carries, the resolution, the amendment is deemed to have been passed by council, and then if that time period to override the veto is passed, then the proposed budget is deemed adopted. I'm going to very quickly go through this because this also becomes a little more complicated, but a little more complicated from a process. Generally, what the in-year amendments are is that a mayor can raise any additional general or special municipal levy, prepare a proposed budget amendment throughout the year. Sorry, that just scared me because I thought it was mine, which is way worse. So there can be those in-year amendments. So throughout the year, if the mayor feels that a special levy is validated because something happened, it needs to come forward, that amendment can be made. And then again, within 25 days after receiving that proposed budget amendment, council considers it. You can propose amendments or and pass that resolution in terms of amending the budget. Then there's another period in terms of 5 days after that 21 day that triggers the veto power of the mayor. One thing to note in the exercise of the mayor's veto powers of any amendments passed is the exercise of those powers are always very quick. If you've noticed throughout this, 2 days of a bylaw, 5 days of the budget. So it's very fast. Once those time periods have passed, there's no longer any veto power. And then we'll go to the next one. Because this does become fairly self-explanatory once you look at it. And this is abundantly helpful in terms of the budget process. But after 10 days, after that expiry period in terms of whether the mayor is going to veto or not, and the mayor decides to veto, again, it's a supermajority of council that can override that. And these are important because once you get into the legislation, you will see that when the legislation first came out, there was a lot of, what are we doing? Because now we're essentially have all of these, we have a structure and an elected structure set out of representation of the municipality. And municipal councils have always been meant to be a broad representative of your municipality to ensure that everyone's interests are represented. And at least in the legal realm, when this was first passed to a lot of municipalities and it delegated, there was a lot of discussion in terms of, oh my gosh, what are they doing to councils? Are they essentially rendering them moot because now there's not as much authority or as much consensus involvement in the decision making. If now that you have read, when you read through it a couple times and you read through this slide a couple times, and I'm happy to provide more information, there is a check and balance always in terms of any time the mayor vetoes, there is a council ability to override that veto in terms of a supermajority, in terms of 5 members of council can vote that veto down. So there is a check and balance that has been built into this legislation to ensure that there is still a voice of the broad council at large, for lack of a better word. So there is this check and balance. So if you notice throughout every time a veto is exercised, there is a time period and then there's another vote, and then that vote has to be a supermajority, like a reconsideration. That vote can vote down the veto. So in terms of the next one, conflict of interest applies throughout. So the conflict of interest cannot, in terms of a budget, the mayor's prohibiting from using the power or exercising the duty prepared a proposed amendment to the budget if there is a conflict of interest, if a conflict of interest arises. In terms of exercising powers, vacancies, and refusals, that's that next head of power. I flipped my page, sorry, go ahead. So this is essentially a summary. So mayoral decisions and directives. Any decision of the mayor must be made public, and those decisions are with respect to governance and policy. So all of those must be made public and publicly posted, open and transparent governance. Mayoral directives in terms of directions made by the mayor given to the CAO or clerk must be available to the public. In terms, both can be revoked and replaced, and the mayor is required to exercise the power and duty in writing. So anything has to be done in writing. In terms of the powers exercised, so it has to be in writing. It make any prescribed information and documents available to the public. And when exercising or performing the mayoral duties, a written record is provided the next business day to each member of council and the clerk. And those are all subject to your MFPA, your Municipal Freedom of Information and Protection Act. In terms of if there is a vacancy in the seat of the mayor, currently that's governed by Section 263 of the Municipal Act. Now it is notwithstanding that, if you're going to fill a vacancy, it has to be within 60 days after a declaration of the vacancy is made. And then within 90 days of, if the vacancy is within, there's a different prescribed period depending on where you are in your election process. So whether it occurs pre-March 31st of an election year or post-March 31st of an election year. If it is in an election year, the timelines are considerably faster. The part now 5.1, which is the new strong mayor section, eliminates the option to appoint a mayor in the event of a vacancy occurring before March 31st in an election year. A by-election must happen. A by-election is required. And if it occurs after March 31st in an election year, an appointment is required. In terms of the immunity, thank you. A decision made or veto power or other power exercise must be done. And the term is legally and in good faith. So all bylaws must be passed in good faith anyways. That has not changed. Bylaws can only be challenged if they're made in a manner that is the term is discriminatory, and discriminatory means that you are treating some segment different from another segment in terms of whatever benefit that bylaw gives. So bylaws cannot be discriminatory or in bad faith or improper purpose. So a good faith bylaw is any bylaws that do not violate those three things in law. So you have to exercise legally in good faith. One interesting change in the legal realm is a judicial review of a mayor's decision or mayor exercise of the mayor authority under strong mayors cannot occur if that bylaw is found to be if that action is found to be in good faith and in accordance with the regulatory requirements. The transition, in terms of the transition, all of those positions continue unless they are dismissed or appointed by the mayor, and that relates to your CAO and your chair or vice chairs of committees. If the mayor declines the powers and duties, there are certain things that you cannot decline that we went through before, but the mayor must issue a mayoral decision to delegate the following powers, and that's the power to appoint the CAO to council, appoint heads of organization units to CAO or to council, to determine the organizational structure to CAO or council, and to establish and appoint chairs, vice chairs to council. So your power to establish, determine functions, and appoint chairs and vice chairs of committees only rests with council. The other can be vested in terms of your delegation to CAO. These delegation powers essentially put you to what currently exists today under the former Municipal Act. Next steps. Your next critical steps are to establish a public registry on your website to explain the powers and duties, and also to set up that posting area of any decisions. We would recommend developing a series of templates for communicating those mayoral decisions, the vetoes, your notice of intent, because then it becomes a very standardized process that limits your ability to challenge. So the more standard process you have in form of a template, you always close your exposure to liability because you're following a standard process that has been implemented. And we would recommend think about this in terms of reviewing your bylaws, policies, procedures to ensure compliance with the strong mayor powers, because there's a couple of them that you should consider in terms of, you'll know right away, and your senior staff will know right away what ones those are. And then at the end of this, in terms of the electronic version that your CAO can send you after, it has a series of links to some really good references in terms of the act and the intended changes of the act. So I know that was a whole lot of information to throw at you.
Very helpful, Paula. Ms. Lombardi, thank you very much. Appreciate that. I might get the question started if that's okay with council, and I'll then go around. So if the legislative can't be done, the administrative and political powers can be delegated. Does the mayor have to use the strong mayor powers to do the delegation?
Yes.
Okay. Second question. Could I ask the council to use, or could the mayor rather, because it's not just about me. First of all, it's 159 communities for the current mayor and the next mayors and into whenever. Could the mayor ask the council to use the strong mayor power? Okay. Question number 3, you talk about research. And that was one of the things that stuck out for me. So playing this through, I say to Ms. Hurd, as CAO, I would like to research whether or not, you know, the infrastructure for sewer and water is up to date in X part of the municipality. I'd like you to do that. What's the process? Does that fall under, has to be written? I have to write an email, I have to carbon the clerk, I say I want some research done. And how does it act versus today? Like, it seemed to me that whole research piece kind of stuck out. So I just wondered if you could clarify the research and then give me an understanding of how that would work.
I'm going to clarify the research, and then I'm going to tell you how I would recommend that you do it as legal counsel. So in terms of the response is, it doesn't say whether it has to be in writing or orally in the legislation. I would say there's an inference that it should be in writing. So you would send to your CAO, you would say in writing, I am looking for this research. That will then be circulated to mayors and council just to say, hey, let me stop there. Don't think it has to be circulated to your mayor and councils. So you would, under the strict guise of the legislation, you would direct, the mayor would direct the CAO to say, I would like this research and I'd like this brought back on this date. That's the strict piece of the legislation. Your CAO then reports back.
And would there be, you talked about there being note made to the public. So would a note have to be made that's to the public saying that the mayor requested research on X, Y, and Z?
On the research, the legislation is silent, and I don't think you have to post that. It's just your decisions.
Thank you.
What I would recommend, if I could,
Please.
so bold, what I would recommend for open and transparent government, because the other thing that sits out, so we have this, it's interesting when the province does this, you have a new piece of legislation that does not sit outside of your old piece of legislation. So this is in the Municipal Act, right? In the Municipal Act, you still have an obligation in terms of open and transparency, and you still have that corporate, that entity of council. So I would say what I would recommend as a best practice as you write the mayor writes the instructions to the CAO, and there just be some form of update to council in terms of what's being researched. That's what I would recommend.
Okay, thank you. Council, questions, please? Comments? Deputy Mayor.
Through you, Mayor, I'd like to thank Paula for a detailed report. This was it was very complex, and you explained it to us in a very nice way. I think it's comprehensible, and I appreciate it.
Councillor Bachman, then Councillor Watson.
Yeah, thank you very much, Ms. Lombardi. I'm just wrapping my head around this, and there's really not much that has changed my opinion of this legislation. But the veto, as I see it, and correct me if I'm wrong, has pretty much just reversed the majority rule, where if we vote on piece, including the mayor, a 4-3 vote moves it forward. But with this 2/3 supermajority to overrule a veto, he only requires, or in case of the mayor, I don't want to use the he, she thing, but they only require 3 votes to maintain the veto. So in essence, or sorry, 2, you're correct, 2. So in essence, majority doesn't rule, veto plus 1 maintains the veto. Am I correct in that?
Microphone, please. For the at-home listeners.
Yes, sorry. That is accurate, but I'm going to put it a little bit in a box, only as it relates to the prescribed priorities of the province. Not as it relates to every bylaw. No. Only as it relates to the prescribed powers of the province, but yes, yeah, that is a way to, that is how the votes roll out practically.
May I follow up for a sec, or Councillor Dave, is that okay? So could you give an example of each?
Of the prescribed priorities, a bylaw comes forward in terms of an official plan or zoning bylaw amendment to build a wide range of housing in your municipality. That would be a prescribed priority. You have a bylaw to enter into a contract for grass cutting or maintaining those administrative functions. That is not a prescribed priority. I would argue that if you have, I think there comes an area in between bylaw that relates to improvements of existing services that are existing are outside of the prescribed priorities. Because if you read the context of the legislation in terms of the background and some of the background reports on this and what prompted in terms of City of Toronto, it is clear that the primary intent of this legislation and the strong mayor powers is to build 1.5 million homes in the province. That's clear. So anything with respect to the housing, it's really to, as the province says, you know, cut that red tape and bring housing forward. I'll say this frankly, in terms of the municipalities that I have done work in, that I've provided advice to, I have not seen any red tape in terms of bringing houses to market. I have seen it move incredibly fast. Central Elgin is one of them, right, in terms of that. But I have seen some municipalities who are incredibly administrative at times and can bog it down. But for the most part, my view in working in Southwestern Ontario, I haven't seen that happen. But your best way to think about it is anything that relates to that's going to bring more housing to the market is absolutely going to be a provincial priority.
Thank you. I have one other follow-up while people are thinking before, or I'm happy to go to councillors. Ms. Lombardi, if the mayor decides that they are going to present the budget in 2026 on February the 15th, could you explain to me how that will affect the council?
I actually do not think you can bring, I do not think the mayor can make that decision. I think if I could you, sorry, you go back to the budget slides. I believe your budget has to be in by February 1st.
If I may, it says February 1st for the mayor to.
Oh, did I get my dates wrong?
No, it's February 1st. That's why I gave the 15th as an option. So if we were to wanted to go status quo, let's say, you just talked about how certain municipalities have planning issues and they're not keeping up. You then lauded Central Elgin saying that we don't have a problem and we are keeping up. We just went through a budget process. It involved a budget committee. There were 1, 2, 3, 4, 5 of us on it. If we wanted that to stay the same and we presented the budget after February the 1st, I want to know what would happen.
Finding do you know what slide I referenced the February 1st? I'm just finding that section. 28, thank you. No, that's okay. It's the one I didn't flip over to, of course. So if the mayor does not, if you're proposing your budget on February 15th, it's a council decision.
Okay. So, and it lists the people that can't be affected, the treasurer, the deputy clerk, police, fire, that kind of stuff. I have a question, and again, this is just, so you need strong mayors to tell the CAO you're delegating it. So question, will you use strong mayor? No, might have to give it to the CAO. Question 2, staff that aren't named in there, that are not at the management level, does any mayor have the ability to, under the current system or the proposed system, affect people that aren't at a senior level?
I do not believe so.
Perfect. So it's not really changed. Good.
That's
Great. Sorry, Councillor Bachmann and then Deputy Mayor. Thank you.
I guess I want to discuss the, excuse me, the actual legislation. When this came into Toronto, being from this area, I really didn't put much thought into it. It's Toronto. It doesn't affect us. Now it's on our doorstep and it is affecting us. The problems that I see is we've all had, I'm assuming in our employment histories, good and bad people we've had to deal with at administrative levels, whether they were incompetent or whether they were unethical or whatever the reasons are that we didn't agree with these administrators. To me, this legislation is a utopian ideal. And this is just me thinking that, hey, everybody's wonderful. Everybody's getting elected for this wonderful, noble cause. As we've seen in below the border, those issues now can crop up where these utopian ideals go out the window. Based on basically my own ethics, I'm looking at this going, if we go into this with, we all have this great, wonderful idea, but we get that one or two people coming from a different ideal, whether it's their own greed or backgrounds, this to me is just fraught with all these dangers. I just see a bunch of red flags. That's just me. Okay, I'm looking at worst case scenarios, and with all that veto power, I see a lot of red flags.
Microphone, please.
If I could, through your worship, I would say this when you read it. I disagree with absolute power corrupts absolutely. That's an old saying from the Roman times. In this legislation, though, there is a overlay of two things. The mayor at all times has to act legally and in good faith. And I know often when a layperson hears, and no disrespect whatsoever, when someone from the public hears me say good faith, they're like, oh, well, what's the check and balance to stop someone from going on a detour and frolic? Good faith is a very legal terminology in my municipal world. And good faith means that that exercise of power cannot be exercised in bad faith. It cannot be exercised for improper purpose, and it cannot be exercised in a discriminatory manner. And by discriminatory manner, I do not mean discrimination in terms of a human rights claim. I mean that, I've tried to avoid, Port Stanley cannot be treated better than, yes, that would be the discriminatory, that balance. So there is legal balances. The problem is, right, same with any normal bylaw that happens. Your bylaws always have to be in good faith. Is that the real check and balance comes from that. Even if there's a super majority vote, there is still a check and balance of your court process, right? In terms of ensuring that bylaws made in good faith and not for an improper purpose.
Just to follow up, and I'm not going to keep dwelling on this. I don't want to beat this, but once again, it comes down to that burden of proof on what's good and bad, to me anyway. I may believe something's in good faith, but it's for the wrong reasons. That's just me, okay? And when it comes down to this, the burden of proof on what's, and I realize the legal system has this, but if I'm believing I'm doing this in the best interests of whatever reasons, I can be influenced, and influence is part of politics, right? And possible influencers may have control or have the ear of the person they're trying to influence, such as a mayor. And once again, there's no disrespect. It's in the broader context of the mayor powers.
Through your worship. It is. So it is not the public who's going to decide what's in good faith or in bad faith. It's going to be a court. Based on based on a significant number of legal standards and principles that have been in place since the early 1800s. So there is a test, and they are very good at determining it. I'll also say this, and I don't say it lightly, because this is a more frank discussion, to be frank, over a coffee. But there is a lot, and I say this partly because it's in a public session, and so I'm going to apologize to the public first. But there is more responsibility on the public in terms of, please come out and vote and make sure you get your best mayor in power, and a mayor that you can trust in terms of to use these powers. We have about a 4.5% voter turnout rate for municipal elections. Everyone get to the election and make sure you exercise your voice, because that's the way really now to do those checks and balances. And the same with every counselor, and I apologize for getting on my soapbox for that, but I mean, it is important, right? I say this frankly at the municipal level, and this is my 25th year of doing this. And in terms, I will say this, look, everything has been downloaded to your municipal councils now. You are the grassroots individuals who make change in your community, and that's a lot of authority for each, and a lot of responsibility for each and every one of you. So that's why I encourage people to go out and make your voice heard. A little off topic, I apologize.
Thank you. Deputy Mayor, did you have a comment?
Yeah, through you, Mayor. The motion to reconsider and the motion to veto something that the mayor has put forward, that's basically the same vote, is it not?
Now it is, yes, very much so.
That would be,
Sorry, if I could, through your worship, the only change is though in terms of a reconsideration, because pre this strong mayor, so pre today, the mayor vote was a tiebreaker, right? The mayor's vote really was, now the mayor the mayor votes as a member of council.
Okay, thank you. And so that vote in this case would be 5-7, the same. And then going the other way, the vote is 3-7 because everybody votes. Thank you.
Excuse me.
Oh,
I apologize. I've been trying to raise my hand and I'm not sure why, but it's not allowing me. May I ask a question there?
absolutely. Councillor Griffin, we can't see you on the screen. Apologies. So we can hear you. So.
Thank you. I'm not sure why that is either. Delaney and I have been trying to work that out. So I do have two questions there. One is, we keep coming back to this talk about the mayor breaking ties, and that isn't making sense for me because there's nothing in the act that says that the mayor does not vote except for ties. And there's also nothing in our procedural bylaws. So I don't understand why this is being talked about as if it's something for our circumstance. But back to what was being discussed about the issue of good faith, I'm really struggling with exactly what Councillor Bachman was asking about here. What's good faith and bad faith? I mean, it's great. Ms. Lombardi, respectfully, what you've said to us is that good faith means you can't make a decision in bad faith. But the act here says that you can't quash these vetoes because they have seeming unreasonableness. And seeming unreasonableness means that we can't gauge whether a decision is logical or not. And if we can't gauge whether a decision is logical, that means we can't look and say, were there exceptions, were there extenuating circumstances? And that makes it very difficult to gauge what is, in fact, good faith or bad faith. We can't see what is consistent favoritism or what is the best possible circumstance for community. So if we can't adhere reason to goodness, then how are we supposed to decide good faith?
Counselor, or sorry, no, Counselor, Miss Counselor, as in legal counselor, Miss Lombardi, please.
So through your worship, and I apologize, I can't see you, but as I indicated, good faith and bad faith are legal terms. And there is a long line of cases that address what is good faith in those circumstances and what is bad faith in those circumstances. So it's just not a nomenclature or languages that have been put into a piece of the legislation in terms of the overlay of the common law. And it's unfortunate at times I will say it's very unfortunate today for the 169 municipalities, because there was not a lot of input, or there's not a lot of transition that you can find in terms of this piece of legislation. And there's little direction from the province on this piece of legislation. So that in that scenario, you would overlay the common law in terms of that body of case law. And I know that doesn't help you practically, but I can come back with a memo and tell you what those bad faith decisions are, because there are about 7, so probably about 10 key Supreme Court of Canada decisions. Bell is one of them that clearly sets out what a bad faith is and what bad faith actions are.
But if I may, what has changed? Has the good faith, bad faith changed with this legislation? It hasn't. It has not. That's what I thought. Deputy Mayor?
Sorry, I wasn't finished with that, actually.
We'll just go to the Deputy Mayor and then we'll come back to you. Thanks, Councillor Griffin.
Thank you.
Through you, Mayor. So Paula, is there a different, like, do we have good and bad faith as far as legislation in council in general without, like, outside of the strong mayors?
Yes, that is the overlay of the common law, that all of your actions since the formation of council has had to be done in either good faith or bad faith.
Councillor Griffin and then Councillor Graham. Thank you.
Thank you. So I do appreciate that there is law, not just specific to this, but in a bigger picture way about good faith. But I suspect if we were to go back and look at those precedents, and Ms. Lombardi could advise on that, but I'm going to guess that when judges have weighed in on what was or good or bad faith, they have decided that bearing in mind what was reasonable, because if you can't decide what is reasonable, you can't decide if someone has done something unreasonable with a specific and not good reason. So that's where I'm saying it's great that the Act doesn't say anything specific about overriding good and bad faith, but when it says we can't use what appears to be reasonable to pass judgment on things, suddenly I'm not sure how we can expect that anyone could judge good or bad faith. Now, the other question I wanted to ask, I'm going to put out here now since I know you can't see when I raise my hand, and that was about priority. And Ms. Lombardi, you stated that we have the priority of housing and that's the whole spirit of this, and therefore mayors can't be seeking out other priorities. But we have already seen one case in this ice storm where a different priority was used with the strong mayor powers. So it appears that although housing was the first reason to give strong mayor powers, there are in fact possibilities of giving other priorities. And so priorities could change at any time. And the only place that we see the word housing in this is in the actual title. We don't see it anywhere else in the writing. So why are we supposed to believe that no other priority could be given when we've already seen one precedent and when it's not written anywhere in the document?
I'm going to get Ms. Lombardi an opportunity to respond. Thank you.
So I'm not saying the legislation is drafted as, perfectly, but it's clear the reference to the prescribed priorities, and you are highly likely to see some regulations come down likely before the end of the year that sets out more of those prescribed priorities. Right now, they are listed as housing, transit, roads, utilities, and servicing. Anything outside of that would have to relate to those items. And I would say an ice storm would relate to the items that likely in terms of transit and utilities. In terms of the reasonableness, and I'm happy to go offline or to get you more information on this, that is actually not the legal test. So reasonableness is not a word that turns on this legislation at all. It is going to be the actions of the mayor in terms of whether they were acted in good faith. That is going to be the legal test that's going to be held to it, because to your point, what is reasonable and unreasonable is a highly subjective standard. And in the terms of a review of a municipal bylaw, what is good faith or bad faith or improper purpose or discriminatory are all very defined terms in the legislation and viewed as being more objective.
Great. Thank you. Councillor Graham, please. Thank you.
So with regards to good faith, what's the timelines and costs for getting that in front of a judge? So let's say a CAO was fired. during a time when the province has given them strong mayor powers to, on a temporary, initially a temporary basis for a ice storm in Aurelia, and then the mayor immediately fires the newly hired CAO. So what are the timelines? What the costs would be to take that to court to see if that is a decision that's made in bad faith?
So if I could, I mean, no disrespect at all. That is a highly fact-specific question, which I do not know the details of the facts on. So I am not going to speak to that specific, but hang on, sorry, sorry. But I'm going to speak generally to your question. So I just want to take it out of the context of the Aurelia case, because I don't know all the details or the background. And yeah, no, but that's in a public session. It's a little unfair because the last thing I want is Ms. Lombardi said that the Aurelia CAO should do this. So I'm not talking about the Aurelia CAO. In general, if there was a reactionary statement under a reactionary action of a strong mayor, as I understand your question, against a CAO for doing something, and they're terminated, what is the process in terms of getting that before the court? And I want to say something quite clearly. I am not here promoting or favoring this legislation or any of this. I am trying very much to give you a black and white, here is the new law as it sits today. So in terms of that, under this new law and under the court system as it currently works, you would bring an application forward very quickly, and it depends what court you bring it in. Some courts are, on civil litigations, I tell people, unfortunately, it's 3 to 5 years on a good day. There are ways to speed that up in terms of through the employment realm, which is why I'm saying the facts really, because you have to look at the contract, if there's an arbitration clause, all of those things, and the cost will depend on who does it. I mean, it is not the ideal process for your CAOs in terms of those the administrative functions in terms of that action, but there is another process in terms of bringing a case forward, but it does take time and it does take money.
So can you give us a ballpark of how long you would be waiting to get a case in front of a judge for a determination of bad faith? And as well, is the municipality going to be paying for 2 lawyers? So if council brings charges or whatever you want to call it against a mayor for using strong mayor powers, the mayor has a lawyer as the municipality, council has a lawyer as municipality. Does that mean we're paying both sides? What's the, approximate cost, ballpark? What's a ballpark timeline? Is it like 3 months or is it 2 years?
I profusely apologize because in any legal case, it flows from the facts. I can tell you, I am doing one in another municipality that I have brought an application for something on a bylaw, and I will have it heard in 6 months. In terms of the who's paying who, but it depends what court, what circumstances, that is so fact specific. In terms of the who's paying what lawyer, in terms of if you are bringing something against the mayor, which has to be an action outside of the responsibility that's given through the strong mayors, that action, the legal counsel will depend in terms of whether your insurer is going to cover both or not. And that's going to depend on your insurance policy. It really is. It's not, I mean, that is not clean. Call your insurer because it's going to depend on what policy you have. I will say this though, if you're talking in the context of the mayor went on a detour in Frolic, not I just didn't like the decision. The mayor went on a detour in Frolic and did something that, I'm going to put a whole bunch of sunflowers in my house and the municipality is going to pay for it, or what, that's a bad example because that would be a conflict. But anyways, if there was some detour in Frolic that the mayor went on, then I think you have other repercussions against your mayor in terms of acting outside of the scope of their duty. And that is something, there is still a duty that overrides all of this. And there is still an oath of office that is taken. There's still all of your codes of conduct that is taken. There's still the overlay. So I don't want anyone leaving here thinking that this piece of legislation supersedes all of the other overlay of the common law and the policies and your codes of conduct and your oath of office that exists, and that currently applies to each and every one of you.
Okay, thank you. Any other questions? Councillor Griffin, do you have a follow-up question?
Thank you. I'm, well, admittedly not really satisfied with the answers we've received, but I don't think there's going to be anything further from that by continuing to ask them. I would like to understand why it is that we keep coming in circles back to whether the mayor breaks ties or votes in every decision when in fact there isn't anything that I can find either in our own policies or in the policies of the Municipal Act that would say that there's a reason for the mayor not to be participating.
Thank you. Any thoughts on that one, Ms. Lombardi, or Ms. Hurd was going to make a comment here?
Hi there, Councillor Griffin, you are correct. There in our procedural bylaw, the mayor votes as one and does not break ties. Some procedural bylaws do have the mayor only voting to break ties, but you're correct. In our instance, the mayor votes each time.
Okay, thank you. Ms. Lombardi, any other comments or questions from your side? Anything else you'd like to mention?
No, thank you. I think we've covered everything.
Well, I appreciate your time. I know that certain municipalities have done information sessions, but apparently not all. So I think this is a wonderful opportunity for everyone to see online, and to, if there are any further questions for folks that want to send them in that we can get answers for. You make the comment that it wasn't a lot of time given when we found out about this and the other 158 places. At the end of the day, I look forward to hearing the council's thoughts on it as we delve a little deeper, but really appreciate your time as always.
Thank you.
Thank you. So folks, it looks like I'm going to ask for a mover and a seconder for a bylaw to confirm the proceedings of council. Deputy Mayor, Councillor Connors, thank you.
Mayor Sell on the motion reads, moved by Deputy Mayor Noble, seconded by Councillor Connors, that bylaw 2025-23 be read a first time and passed.
All those in favor? Opposed? And that's carried. Could I get a mover and a seconder for adjournment, please? Councillor Bachman, Deputy Mayor, thank you.
Mayor Sell on the motion reads, moved by Councillor Bachman, seconded by Deputy Mayor Noble, that the special meeting of council dated Thursday, May 1st, 2025 be adjourned at 5:08 p.m. with the next council meeting scheduled for Monday, May 5th, 2025.
All those in favor? Opposed? We're adjourned. Look forward to seeing everyone.